Good morning and welcome to today's webinar, Employee Benefits, Legislative and Compliance, What's Changing Next Year? My name is Michelle Wilcox and I will be your moderator today, and I will also be monitoring questions you may have during the session. Before we open up, let's review a couple of key items. If you have, all of the webinar materials we discussed can be found at the URL currently showing on your screen. I will be sharing this URL in a follow-up email, so don't feel like you need to write it down right now. If you have trouble with your internet connection during the webinar, we recommend leaving the presentation and logging back in. We do not control the audio, your devices do. So if you have audio difficulties, try adjusting the volume settings on your device. If a telephone line goes down during the call, hang up and call back again to the same number. If all lines go dead, watch the on-screen chat box for an alternative call-in number. Feel free to ask questions or provide feedback by using the chat box or questions box during the webinar. If you are using a tablet, you may need to tap on the screen for the options bar to appear. Then you can select the appropriate option. We may not respond immediately, but we will work your questions or feedback into the presentation. If we can't get to your comment or question during the session, we will be online afterwards to respond, or we may follow up in an email if we run completely out of time. You may also email us at moderator@aspenrmg.com for up to 48 hours after the webinar. This will be a 1-hour presentation. Questions and comments are very much encouraged, and the presenter will be answering questions at the end. And lastly, we have a number of upcoming webinars covering a variety of topics, including those listed at the Heffernan webinar website. With that, let's begin today's webinar, Employee Benefits, Legislative and Compliance, What's Changing Next Year. Our presenter today is Christina Villeco. Christina has her BA from Colgate University and her JD from New York Law School, where she graduated with honors. Christina has been with Heffernan for 10 years, where she advises clients of their health and welfare plan compliance obligations under applicable law, such as ERISA and the Affordable Care Act. A member of the Legal Counsel Working Group of the Council of Insurance Agents and Brokers, Christina co-authors comments to Congress on pertinent industry legislation such as Lower Costs, More Transparency Act, which is HR 5378. She has been practicing law for 14 years and is admitted to the state bars in both New York and Connecticut. When not working, Christina volunteers with the Gal's Best Pal Animal Rescue in Massachusetts and is a member of Flat Out Love, a nonprofit organization for breast cancer survivors advocating for early detection. With that being said, I'm going to go ahead and change over the screen to you, Christina, so we can begin.
Thank you so much. So I'm going to assume that everybody is here today because they love compliance as much as I do. So we're going to jump right in. We're going to start with an update from the IRS about the employer mandate in 2025. Touch on some new Medicare improvements that are coming for 1/1/2025. A brief update on the Affordable Care Act, Section 1557. A review of a couple significant Supreme Court decisions. What now for employer action items, and then looking ahead into 2025. So content disclaimer that the information presented is general in nature, intended to present an illustrative overview of benefits only. Nothing here is intended to be legal advice nor tax advice, and no client relationship is established between presenter and attendees, just to get that out of the way. Okay, so the easy stuff first. So everyone here is very familiar with the employer mandate, nothing new. In 2025, the Section 4980HA NB penalties will be going down for the first time. So that is a change from what we're used to, where they generally index upwards. For 2025, they are going to be indexing downwards slightly. So under A, which is the larger penalty, if an employer does not offer coverage to 95% of its full-time workforce, the employer would be subject to a penalty equal to $2,900 multiplied by all full-time employees, less 30. Under the B penalty, which is the smaller penalty, if an employer offers coverage that is unaffordable or doesn't offer minimum value, the employer is subject to a penalty equal to $4,350 times the number of full-time employees that actually receive a subsidy to purchase insurance on the health exchange. So next, a little bit of a more intricate area for 2025. Medicare will be changing slightly as we get into the new year. Following the passage of the 2022 Inflation Reduction Act, CMS issued a final rule this spring that revises the Medicare Advantage program and the Medicare Prescription Drug program significantly for enrollees. Some of the key items of this are improved access to behavioral health services for Medicare enrollees. Medicare Advantage plans encouraged to engage in outreach efforts so that enrollees are aware of the supplemental benefits available to them. More flexibility to substitute lower cost biosimilar and biological products for reference products on the Medicare formulary. And most significant of all, there will be a $2,000 cap on out-of-pocket prescription drug spending. So currently the prescription drug cap is $8,000. So this will be a pretty significant difference for employer plans. And if everyone is familiar with creditable coverage, so employer plans today are expected to provide creditable coverage to their enrollees. This means that the employer plan on average will cover at least as much as the Medicare Part D plan covers. Annually, employers are required to provide a disclosure notice to their employees that states whether or not their plan is in fact creditable. Employees that do not have creditable coverage prior to joining Medicare will pay a higher price for that Medicare plan in eternity. This is generally considered the non-creditable coverage penalty. So as we approach 2025 with this new $2,000 annual cap on prescription drug spending, it is possible and likely that certain employer plans that are creditable as of today in 2024 will no longer be creditable as of 2025. This is especially true for high deductible plans. So in the past, high deductible plans could not satisfy the Safe Harbor Medicare creditable coverage testing, so that isn't necessarily going to change, but the more in-depth actuarial testing, which sometimes renders a high deductible plan creditable and sometimes renders it non-creditable, that testing is going to have to be rerun for all health plans as we approach 2025. So we will touch again on this in the next section about action items, but we do expect to see some significant changes to the creditable status of many employer plans. Okay, next, so ACA Section 1557. So to frame this a little bit, I'll just remind everyone that in 2020, we had a very significant Supreme Court decision in Clayton v. Bostock, where the court stated that the term sex within Title VII includes gender identity and sexual orientation in terms of protected status. The Affordable Care Act, Section 1557, generally borrows this language. It's a very brief statement. It prohibits discrimination under any health program or activity, any part of which receives federal financial assistance on the basis of race, national origin, sex, religion, or color. So based on the 2020 decision, we know that sex now includes sexual orientation and gender identity. When a rule is brief, such as this one, the agencies generally step in with implementation guidance so that we know what exactly an employer is to do in order to comply with the law. The rule implementing this section was published May 6th, and it has implications for employers as health plan sponsors. So many employers will rely on their fully insured carrier to comply with this law and won't have to do anything specifically. However, self-insured plans that receive federal funding will need to take notice and ensure that their plans have the substantive coverage. Medicaid and Medicare are the most common sources of federal funding that employers receive that will render them subject to this particular section of the Affordable Care Act. As it stands today, there is no federal law requiring coverage for gender-affirming care. However, the courts have held that exclusion of gender-affirming care does violate Title VII. So it's a little bit confusing for plan sponsors in this area at the time because there isn't, again, a law on the books, but it's more of an indirect way that an individual can have a right of action to sue an employer on, and we will again touch on this again in the later slides. Okay, so my favorite part, the Supreme Court. Okay, so today we have several notable decisions that really do impact employers in the day-to-day administration of benefits. So the first one to note is the FDA v. Alliance for Hippocratic Medicine. On June 13th, the court unanimously upheld the current FDA protocol for providers administering a specific drug used for abortion, which has provided an expansion in the access to individuals that are prescribed this drug. The plaintiffs here basically objected to the expansion such that this drug was becoming used by so many people. The court here found a lack of standing to the challenge to the FDA protocol, which is very different than finding on the merits of the case. So arguably this leaves the issue open for future plaintiffs that might have an actual specific injury or have what legal term is standing to sue again under this statute. So again, not necessarily conclusive for the matter, but it's considered a win for the FDA's protocol for the time being. The next significant decision, which is very recent, Loper Bright Enterprises. So this case was significant for several reasons. It was a much anticipated opinion. The court held by a vote of 6-2 to overturn a long-standing precedent known as Chevron deference. Chevron v. Natural Resources was decided in 1984, and since that time, federal agencies such as the IRS, the EEOC, HHS have been given what's called deference in how they interpret and implement the law that are under their jurisdiction. So this means that in the past, the courts have given respect to the way that a specific agency decides to interpret laws under their purview and how those laws are followed. Any conflicting interpretation would be decided in favor of the agency's argument or the agency's interpretation. So the recent decision in Loper Bright means that this practice is no longer proper. So Justice Roberts delivered the majority opinion, but Justice Gorsuch, in a concurring opinion, stated that they don't believe that the court will resolve cases and controversies without any systematic bias in the government's favor going forward, that they feel that there are other avenues for that type of discourse and that going to court is not necessarily the place to do it. There's been a lot of controversy in response to this decision, and we will touch on a little bit of what that means in the next slide. Another significant decision to take note of is Brayward v. Becerra. This was decided at the end of June, where the court essentially, the Court of Appeals for the Fifth Circuit, so not Supreme Court, but we are likely heading that direction. The Fifth Circuit affirmed the lower courts holding that certain preventative care services, which are covered without cost share under the Affordable Care Act, are invalid. But the court reversed a nationwide injunction, essentially saying that the lower court had to do a little bit more work on their end and do a little bit more research into the different agencies that develop what we consider preventative services for purposes of the mandate. So this, again, will be very significant for plans. Preventative services are one of the core aspects of the Affordable Care Act. So a challenge to this part of the Affordable Care Act is significant. So it is likely that we will see the Supreme Court address this issue in its next term. They come back in October. So we certainly will be following that case closely, but it's something definitely to keep on our radar. Okay, so what now with everything we've kind of mentioned? So the first issue is that agency interpretations of many laws impacting employer health plans could be open to challenge now that we have the overruling of Chevron. For one, the Equal Employment Opportunity Commission's wellness rule, which govern how employers can implement wellness programs and offer incentives for employees that participate in different wellness activities reasonably designed to improve health outcomes, that is in jeopardy. The Department of Health and Human Services rules that surround HIPAA and how employers are to comply with their various obligations under HIPAA as sponsors of health plans, the IRS regulations related to the ACA. These are just a few of the examples of federal agency determinations that govern the day-to-day activities of employers that are in jeopardy now that we have Chevron overruled. As of July 30th, there are 3 district courts that have struck down provisions in the non-discrimination provisions under the ACA that prohibit discrimination based on gender identity. So the court holding from 2020 that we mentioned in Clayton, where the court found that sex is inclusive of gender identity and orientation, that is now in jeopardy. Section 1557 is the only federal protection on the books for gender identity and sexual orientation. And now we have 3 district courts that have essentially struck down the ability of HHS to enforce this mandate. So that is very significant. The first is a Texas district court that blocked enforcement of the final rules that implement 1557. So again, the direction kind of going backtracking from the win that was received in 2020 with the Clayton decision. And then a Mississippi federal court postponed the effective date of the HHS discrimination rules under 1557 as well. So again, something that we're certainly watching. Employers, as of right now, are not advised to make any changes to their plans based on these court decisions. It's just something that we're watching to see what will happen. There is a nationwide injunction at the moment against the ability of HHS to enforce 1557, but again, not necessarily an action item for the time being. Looking ahead a little bit, I think the biggest question will be how the federal regulatory guidance changes based on the fact that Chevron is overruled. The EEOC, DOL, and IRS have numerous FAQs and interpretations that fill gaps in existing laws where there's brevity and cause for multiple interpretation. Employers rely on these in their day-to-day administration of health and welfare plans. So if the foundational interpretations are challenged in the courts, justices won't necessarily give deference to what the agency has said in the past, which almost opens an entirely new field for how to interpret a law and then for employers to know how to comply with that law. Also, something looking ahead, employers will want to watch for changes to the creditable status of their existing health plans. So especially plans that are off calendar year. 7/1 is a very popular renewal date for a lot of clients. Those plans will have to be rerun through the creditable coverage tools to decide if they are still creditable as of 1/1. And this needs to be done prior to the annual Medicare open enrollment period, which runs October 15th through December 7th every year. So if there is a change to the creditable coverage status of a plan, employers are required to give a new notice out to employees to enable them to make informed decisions about their Medicare choices for the 1/1 effective date. So this is, again, something that this is the time to be doing and reaching out to carriers to ensure that those plans are still creditable. And if they are not creditable, making sure employees are aware of what that means for them and what their options are for the upcoming open enrollment period. Additionally, Section 1557, which, as I mentioned, is the first federal protection for gender identity in health plans, is in jeopardy. We do not know exactly what the next step will be here since there is this injunction. We don't recommend any action be taken on behalf of that injunction, but it is definitely something that with the upcoming election, we are watching very closely. And it's also worth mentioning that there is excessive pharmacy benefit manager litigation happening. Just a couple weeks ago, the House held very in-depth hearings with the heads of the biggest PBMs, asking all kinds of questions about pricing and cost. And the answers were interesting, not necessarily complete. So I think that one of the things to watch as well is coming out of Congress, we have the PBM Transparency Act of 2023. This law would require annual disclosures by the PBMs to the FTC. It would also prohibit PBMs from charging carriers more than their pharmacy reimbursement rates, which right now is a fairly common practice. So that would be a very large change to the PBM industry. Largely, the PBMs have been exempt from many of the transparency and coverage implementations that we've seen come in, phased in since 2021. So this is kind of a signal that, you know, that reign of PBM domain should come to some kind of an end. So we're hopeful. There's just been much more light shed, many articles written about what the practices are kind of behind the curtain. So it's definitely something that we're watching carefully. Some references that we'll share at the end of the presentation as well, in case anybody wants to read for themselves. And we would love to have some questions on everything that we just discussed.
Thank you, Christine. That was a lot of information. We didn't really have any questions other than wanted to remind everybody this was recorded, and we will be sending a link, an email with a link, I'm sorry, that will enable you to have access to the presentation itself. And I think, didn't we have another question, Jenny?
Yes, thank you. So I saw a question come in that asked Christina, should employers with self-insured plans take any action in light of the 1557 injunction that you mentioned?
So very, very good question. As of today, we would say no action is recommended. Again, because there is no federal law that requires gender affirming care, we would say that your plan as it stands now shouldn't necessarily be changed. However, there is still a right of action for an individual to sue their employer plan if the plan does not cover that care and they seek that care and they are then injured as a result of not receiving that care. It is something to be very, very cognizant of and discuss with your benefits advisors before making any changes or before excluding gender affirming care from your plans. Absolutely.
Another question that I saw was, what advice do you have for employers in terms of action items now as Medicare open enrollment is approaching? And I think this is in reference to some of those changes in the Medicare limits there.
Yeah, so this is, now that we're in August, this is generally the time that we tell clients that they should begin sending their creditable coverage disclosures to employees to enable them to make their Medicare enrollment decision. So while it's only required for employees ages older or those approaching age 65, so perhaps age 64 in the fall, we really recommend giving it to all employees because you just don't know if there's dependents at home that are Medicare eligible for a variety of reasons. So this is the time to work with your benefits advisor on deciding, is your plan still creditable as of 1/1? Again, a lot of high deductible plans that pass the in-depth actuarial testing for 2024 may not pass for 2025 given that $2,000 out-of-pocket cap. So this would be the time to find that information out. If a carrier will not confirm the status, you might need to do a little bit of digging with an advisor, a TPA, to determine what the employer can do to get that confirmation, because for an employee that's either 65 or reaching 65 that intends to retire or just wants to stay employed but wants to know what their Medicare options are, that creditable status will be very important. A penalty for joining is based on how many months you had non-creditable coverage. So if an employee intends to work for 3 more years and their plan is not creditable, that penalty when they do enroll could be significant. So it is a very specific individualized determination. It's not an across the board rule that if it's not creditable, you can't, you need Medicare. It's not that simple. So it's something that we recommend working with your advisor on presently to get the determination of the status and then what the employee's options are going forward.
Okay, we did have another question. It says, if your prescription plan is not credible, do we have to amend the plan to be credible?
So that's a very good question. So there is no requirement that an employer offer a creditable plan. So the only requirement is that the employer disclose the status of the plan to all employees. So if an employer has a creditable plan that as of 1/1/25 will no longer be creditable, they just have to tell employees of this fact, and then the employee would be able to join Medicare if they want to. They could stay enrolled depending on how many months they plan to have that non-creditable plan prior to their Medicare enrollment. And then in terms of changing plans mid-year, if the plan, let's say you have a 7/1 plan that was creditable for 2024, and as of 2025, it no longer will be creditable, you would probably have to work with your account executive to see if you can offer another plan alongside that's creditable. I don't believe you'd be able to change the plan mid-cycle from non-creditable to creditable. It would be re-rated, and generally it would have premium implications because the out-of-pocket costs would generally have to be reduced. Sometimes using an HRA is a way to take a plan that on its own wouldn't be creditable, and by giving that HRA piece to employees, set the out-of-pocket to an extent that would render the plan creditable, but it's a very particularized determination. So you can't make blanket statements about what those implications are for the plan.
Okay, thank you. I think that's all I have. Jenny, do you have any others?
Actually, I have a question for myself, Christina. You had talked a little bit about some of the PBM legislation coming out. Can you address whether the Supreme Court is going to address all the ERISA preemptions for all the laws that are going on the state level towards PBMs?
So thank you, Jenny. ERISA preemption is my second favorite topic after the Supreme Court. So thank you. So yes, when there's a circuit split, which means that the circuit courts in the country are coming out on different sides of the same question, and the question is very central to a law such as ERISA, that's generally an indication that the Supreme Court will grant certiorari, which means they will agree to take the case. Because we have a split, we have so many states that are issuing regulations aiming to regulate the pharmacy benefit managers operating in their states. And we have, again, a circuit split. Half the circuits say, yes, that's okay. Half the circuits say that can't happen because ERISA preempts, meaning it takes precedent in an area where two laws are on point and they each say different things. So as we approach the 50th anniversary of ERISA in September, I think it's a really good time for the Supreme Court to step in and decide the question once and for all. If they do decide that ERISA preemption takes hold here and it does prevent states from passing laws on PBM management, they're going to also have to do something to help with the PBM regulation, which is getting out of control. So, you know, it depends on where their position is. If we see any changes in the court anytime soon, which I don't think we're expecting those too soon, but it is just something that it's an important issue to answer. And I do think it has direct implications for prescription drug options as we go forward. And in the in the realm of 408(b)(2) broker disclosure requirements and how plan fiduciaries are required to ensure that their plans are paying reasonable fees to their healthcare providers. This all really lays into one another when it comes to PBM and management of these plans. So I think that so many issues kind of hang on where the ERISA preemption argument ends up. So I do think it's something that the Supreme Court is going to have to step in and take up in their next term.
Great, that's a lot of information, and looks like everybody's pretty quiet. So if you do have questions later, we are taking questions for up to 48 hours. I'd like to thank you all for attending today's webinar presented by Heffernan. We will send the information by email with instructions on how to access a copy of the presentation on our website. Thank you, Christina, for your time and expertise today. We hope all the attendees found today's webinar to be a valuable use of your time. Be sure to join us on August 13th for our employee onboarding, the importance of safety from the start webinar. And thank you all and have a great and safe day.
Thank you so much.